My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for participating today in this community conversation. Case Law Update, March 2023 by Luis Sarmiento. ECHO is a 50-year-old statewide nonprofit association established to support HOAs and HOA board members and your engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. You'll find these now on your screen. In addition, slides were sent to registered attendees. Please take a moment and review our housekeeping items. Please use the chat icon to report any technical issues that you might have and to communicate directly with participants in the webinar. Use the Q&A feature to ask questions. We do not monitor the chat feature for questions, so please use the Q&A feature. Today, we have a large audience of HOA board members and some attorneys. We will do our best to answer questions, but we may run out of time. To help us select the most relevant questions, please use the thumbs up icon found in the Q&A feature. Simply click the upvote icon to select your favorite question. We will answer the questions with the most upvotes first. Please keep your questions general and short in nature. Questions about specific situations are better asked of the attorney serving your association or another appropriate industry professional and expert familiar with your situation. I will respond in writing to some questions during the presentation. All other questions will be answered during the Q&A session at the end of the presentation. Now, let me direct your attention to your monitors, where you will find our disclaimer. None of what is said during the seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to connect and contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you very much. This event, as well as all our events, is made possible by our generous professional sponsors. Please join me in thanking today's premier sponsor, the Kevin Boland Insurance Agency. Today's registration sponsors are CID Consortium, LLC, and Levy Erlinger and Company, LLP, CPAs. And now a little from Kevin about the Kevin Boland Insurance Agency.
Hi, everyone. Kevin here. I am very proud to be a premier sponsor of today's ECHO educational event, and I will be sponsoring a lot of ECHO events this year. It really feels good for me to give back because I served for 3 years on my board, and I came into the industry for associations about 6 years ago. If I wasn't able to go and attend a lot of ECHO educational events, my learning curve would have been slow. Instead, it was accelerated, and I think I was able to give back more to my association where I serve because of ECHO. So happy to do it. Okay, so a little bit about my insurance agency. We are located in downtown Novato, and we have 3 licensed insurance agents besides myself working for me. One of them is my wife, Audrey, who's much more organized than her husband. So we run really efficiently here. We give great service to our boards and our managers. And believe it or not, after only 5 years in the industry, today we insure over 50 homeowner associations in Northern California. The reason for that is besides great pricing, we have great coverages. And the one coverage I want to talk about today in a little 1 minute that I have to talk is our directors and officers insurance policy. As all of us, that serve on the board know, it's important to have a really good policy to protect ourselves and our association because lawsuits are rampant in the state of California today. One type of lawsuit is called a third-party discrimination lawsuit. This means that someone like a tenant, a guest, or a professional vendor were to sue the association claiming discrimination. Well, believe it or not, a lot of D&O policies out there have an exclusion built into their policy, which says we will not pay for third-party discrimination lawsuits. That is a big gap in your insurance. So if anybody wants to learn more about this, please give me a call. And of course, later on this year, when you renew your insurance, if you call me for a bid, I can put together a really good competitive bid. I'll look at all of your exclusions, your endorsements, and your property, your liability, your D&O, your fidelity coverage, workers' comp, and just give you a second opinion about where you stand. And only a farmer's agent can give you a farmer's insurance bid on your association's insurance. A lot of the solo brokers out there just can't do that. And again, there's a reason that we have 50 associations today. So please give me a call, give my team and I a chance, an opportunity, and we'll show you what we can do.
Great. Thank you very much, Kevin. We appreciate that message. And I want to say that we will have an Ask the Expert About Insurance program in March. So look forward to having that, and you can have many of your questions answered then as well. I'm sure Kevin will participate in that as well. Please support our professional members and especially our sponsors. They make our educational programming possible at little or no cost to you. And now on with today's program. Louis Sarmiento is an associate at Shear Smith and Kinney LLP, where he advises homeowner associations and other mutual benefit corporations, businesses, and individuals on common interest development, real estate, corporate, and general business matters. Louis advises homeowners, association boards, and officers on matters including governance, development, and enforcement. Louis, go ahead and take it away.
Thank you very much, Dave. So for today, I just want to, at the very beginning, go through a quick roadmap of the cases we'll be covering. The cases are either from the Supreme Court of the United States, from the California Supreme Court, or from the California Court of Appeal. And these cases will be from either 2022 or from 2023. So our first case will be a First Amendment related matter, and in which the public censure was really at the heart of the claim, and dealing with the member of a public community college district board, and it was found that that was not a First Amendment violation. Also at issue was a mediation agreement where the non-disparagement agreement clause in the mediation agreement was found not to apply to statements in litigation. There's also a construction defect case in which the HOA was found to have standing to bring defect claims for the common area, and the HOA may have standing for the individual units. More on that later. And then on corporate books and records, court found that the directors have an absolute right to inspect all books, records, and documents, with exceptions in extreme cases. We'll also go over a case related to premises liability, where the building owner was found to have no duty to protect against the open and obvious danger posed by the roof where there was no foreseeability of harm. We've got a short-term rental license case where the city's regulation of the licenses were found not to violate the licensee's substantive due process rights. And finally, we've got a secret challenge. The opponents were found to have not exhausted the administrative remedies before seeking the judicial involvement, and that ultimately got the case thrown out. So for our first case, this is the Houston Community College System versus Wilson. This is a United States Supreme Court case where the key question was, is the public censure of a member of the Board of Trustees for a public community college district a violation of the First Amendment? So the parties here are Houston Community College System, or HCC, which is a public entity that operated various community colleges in, as you can imagine, the Houston area. The HCC Board of Trustees consists of 9 members. Each are elected to serve a 6-year term. And the other party is Dave Wilson. He was a member of the HCC Board of Trustees, and he was elected to public office in 2013. So for some background, due to escalating disagreements between Mr. Wilson and the board about the best interests of the HCC, and after multiple lawsuits filed by Mr. Wilson, in which he challenged the board's actions, the board first publicly reprimanded Wilson in 2016. Mr. Wilson continued to charge the board in media outlets as well as in state court actions with violating its ethical rules and bylaws. Mr. Wilson's actions included arranging robocalls to publicize his view, hiring a private investigator to surveil another trustee, and filing 2 lawsuits in state court against the board and HCC, which cost HCC over $270,000. So in 2018, the board adopted a public resolution censuring Wilson and stating that Wilson's conduct was not consistent with the best interests of the college and not only inappropriate, but reprehensible. The board imposed penalties, including deeming Wilson ineligible for the board officer positions during the year 2018. So Wilson amended his pleadings in one of his already pending state court lawsuits. He added claims against HCC and the trustees, asserting that the board censure violated his First Amendment. So now let's discuss how it got to the Supreme Court. First, he amended the lawsuit against HCC and the trustee to get it removed to federal court. The district court granted HCC's motion to dismiss the complaint and concluded that Wilson lacked standing. Third, Mr. Wilson appealed, and on that appeal, the Fifth Circuit Court of Appeals reversed, holding that Mr. Wilson had standing and that his complaint stated a viable First Amendment claim as to the censure resolution. And now that there was a 2-step analysis, first, the court concluded that the verbal reprimand against the elected official for free speech addressing a matter of public concern is an actionable First Amendment claim. And then next, the court reasoned that the board's imposition of other punishments, such as limiting his eligibility for officer positions, did not violate his First Amendment rights because Mr. Wilson did not have an entitlement to those privileges. So fourth, the HCC brought review by they sought review by the Supreme Court of the Fifth Circuit's judgment that Mr. Wilson may pursue a First Amendment claim based on purely verbal censure. So the First Amendment prohibits laws abridging the freedom of speech. So we've seen in case law that this has been applied to mean that the government may not impose prior restraints on speech. But generally, government officials are prohibited from subjecting individuals to retaliatory actions after the fact for having engaged in protected speech. And examples of this include arresting private individuals, prosecution, or dismissal from government employment. So to be successful, the plaintiff must show that, among other things, that the government took an adverse action in response to the plaintiff's speech that would not have been taken absent the retaliatory motive. So in the Supreme Court's limited decision, the Board of Trustees' verbal reprimand in this particular case of a member of the same elected body did not rise to the level of an adverse action that violates the First Amendment. And it did so for a few reasons. First was that Wilson was an elected official. And in this country, we hold elected officials to shoulder a degree of criticism about their public service from their constituents and their peers. Second, the only adverse action before the court was a form of speech from colleagues that concerns the conduct of public office. So essentially, it was first one's free speech rights being used to discuss and comment on another free speech rights. So the implication for common interest developments, the verbal reprimand or censure of a board of one of its members is not a violation of the First Amendment. So note that the key distinction here is that the HCC Board of Trustees is a public body. CIDs are private entities. So one key element is the fact that there's no government actor here. The violation of, I know we hear this a lot in media and whatnot, but when it comes to free speech and the First Amendment, the issue really requires a government actor. So the next case, Olson v. Doe. This is a decision from the California Supreme Court, reviewing a decision by the Second District Court of Appeal. The key question here is, if parties agree not to disparage one another, does that apply to statements made in a later lawsuit arising from the same alleged misconduct? So the parties here are Jane Doe and Curtis Olson. So Jane Doe and Curtis Olson each owned units in the same condo building. Doe sought a civil harassment restraining order against Olson pursuant to statute. And as a result, the court ordered mediation. The parties agreed not to contact or communicate with one another or guests accompanying them, except in writing and or as required by law. They were prohibited to go there. They were ordered to go their respective directions away from one another if the parties encountered one another in the common area, and not to disparage one another. So for context, Doe and Olson met in 2002, and they worked together to acquire and preserve a historic apartment building, sorry. Olson acquired the building, converted the apartments into 8 condo units, and ultimately became the owner and part-time resident of one of the units. Olson served as the president of the building's HOA from 2013 to January 2016, and Doe resided in one of the condo units. In October 2015, Doe sought a civil harassment restraining order, including allegations of sexual battery, peeping, harassment, and threats to Doe's life and property, and sought both personal conduct and a stay away order against Olson. The court granted Doe's request for a personal conduct order against Olson and issued a temporary restraining order, but the court denied Doe's request for a stay away order in advance for the hearing. In December 2016, Doe filed an unlimited civil lawsuit against Olson and various other defendants, including other residents of the building, the HOA, and the property management company. Doe sought damages for a variety of claims, including sexual battery, assault, discrimination, and discrimination based on perceived ethnicity, religion, and marital status. In May 2017, Olson sues Doe for a breach of contract damage and specific performance. Then Doe filed an anti-SLAPP motion. The trial court granted Doe's motion to strike under that anti-SLAPP motion. Then the Court of Appeal affirmed in part, reversed in part. Then the California Supreme Court granted review. So let's take a look at that statute. Pursuant to section 425.16, a party may file a special motion to strike a cause of action on a particular, to strike a cause of action or particular claims underlying a cause of action that arise from activity that is protected under that statute. The moving party must establish that the challenged claim arises from activity that is protected. And if that moving party does so, then the burden shifts to the non-moving party for them to demonstrate that the merit of the claim is established by the established probability of success. So before the trial court and on appeal, Olson and Doe's administrative and civil complaints, they conceded that the conduct that gave rise to Olson's actions for breach of contract and specific performance actually does constitute a petition dealing with activity protected by the statute. So therefore, the court was only looking at whether Olson had showed the probability of success. So that gets the only item that was raised to the Court of Appeal is whether Doe breached their agreement by filing the administrative and civil complaints against Olson. The Court of Appeal held that Olson failed to prove the requisite minimal merit for his claim for specific performance, and the court affirmed the portion of the trial court's order. So here's the language of the disparagement clause. It's very simple. The parties agree not to disparage one another. So the court looked at context for the explanation of the intent of the parties, and in light of the language of the disparagement clause, the mediation agreement as a whole, and the broader context in which the agreement was negotiated, the Supreme Court held that the non-disparagement clause did not apply to statements made by Doe in the litigation context. So it found that Olson had failed to make a prima facie showing on this element sufficient enough to overcome Doe's special motion to strike. The case ultimately turned into an ordinary question of contract interpretation. It said that Doe had no obligation under the contract to refrain from making disparaging statements in litigation. So Olson could not defeat Doe's anti-SLAPP motion. So next, the implication for CIDs. Explicit language is important. Parties intend to have a release of claims as part of the settlement agreement. It must include it in the agreement. Next case is Riverside at Washington Square HOA, the Superior Court of Yolo County. So this is a California Court of Appeals decision on a challenge to the Superior Court of Yolo County's two orders. And notably, ECHO members John Chapman, Mark Intieri, J. Spencer Edgett, and John Bumgardner of the firm Chapman and Intieri filed a brief for ECHO on behalf of the plaintiff HOA. It did so via an amicus brief or a friend of the court brief. So let's take a look at the association. Indicates, gives you an idea of the development. So this development was built in 2007. And due to the recession, only 3 of the 25 residential units were sold to individual owners. The developer sold the remaining 22 residential units in a bulk sale to the defendants, who sold the units to individual buyers from 2012 to 2017. The plaintiff filed a construction defect lawsuit against the developers and various entities involved in the design and construction, as well as the defendants. The plaintiff alleged generally that there are defects in the structures, components, and common areas of the development. And attached to the complaint was an exhibit that identified defects in 6 of the residential units to some detail. So for example, one of the units, there was signs of water intrusion under the stairs in the powder room and around the foundation. In another unit, the stucco around the window was cracked. But the exhibit and the complaint did not identify any defects in or damages to the common area. So there were 7 causes of action dealing with violations of statutory standards and residential construction contained in the Right to Repair Act, a breach of implied warranty, assigned rights, breach of contract, intentional or negligent non-disclosure, intentional or negligent misrepresentation, and breach of fiduciary duty. So the defendant filed a formal objection to the claims, a demur, to all of the causes of action, asserting that the claims against them, in their objection, they stated that plaintiff lacked standing, among other things, to sue for damage to the common area or to the separate interests of the association, and that the HOA was not obligated to maintain or repair the individual residential units. According to the defendants, only the common area, the only common area in the development is a street known as Lot A, and the plaintiff is only required to maintain or repair that common area and the trees located in the public right-of-way, and finally the roof drains that connects with the city's right-of-way. The defendants argue that none of the defects alleged in the complaint or identified in the exhibit involved either common areas or any portion of the individual units that the plaintiff is required to maintain or repair, and that the plaintiff thus did not have standing under Civil Code Section 5980 to bring this action. So the trial court found that the plaintiff did not have standing to bring the suit. So at the appeal court, the issue was, does the association have standing to bring the suit? So note that the requirement of standing is rooted in the idea that an action must be prosecuted by the real party in interest. Stated another way, the party that is harmed must be the one that brings a claim for the harm. The plaintiff argued 3 separate statutes as conferring standing on it to bring this lawsuit. First is Civil Code Section 5980. Second is Civil Code Section 945. And then finally, Code of Civil Procedure Section 382. So let's take a look at those. The trial court in this case found Section 5980 did not confer standing on the plaintiff because none of the defects identified in the complaint identified either common area or separate interest that the plaintiff was obligated to maintain and repair. The plaintiff acknowledged that the heart of the case involves the defects in the member's home, which they do not own and which plaintiff has no obligation to repair. However, the plaintiff argued that it did allege that there were defects in the common areas. In particular, it alleged that there are defects in the structures, components, and common areas of the development. And then they also allege that the plaintiff's members have sustained a loss of the use and the enjoyment of the respective units and the common areas because of the defects and the resulting damages. Next is Section 945. So 945 is part of the Right to Repair Act, which sets forth detailed statewide standards that the components of a dwelling must satisfy. It also establishes a pre-litigation dispute resolution process that affords builders notice of the alleged construction defects and the opportunity to cure such defects, while granting homeowners the right to sue for deficiencies, even in the absence of proper damage or property damage or personal injury. Next is Section 5980. The trial court found that by referencing this section, as to Section 945, the trial court found that by referencing Section 5980, Section 945 essentially incorporates Section 5980 standing requirements. And again, 5980 states that CIDs have the right to bring a suit for governing document enforcement or for bringing for damage either to the common area or to separate area that the CID is obligated to maintain and repair. So now into the third statute cited by the plaintiffs as a separate source of authority, 382. So there's a line of cases that point to Section 382 as being the statute that authorizes class actions. There's also a line of cases that holds that Section 382 authorizes a representative action that is not a class action, including a number of cases in which the Court of Appeal determined that HOAs have standing under this section. So after much consideration of canons of statutory construction, the Court of Appeals determined that Section 382 and Section 5980 establishes 2 different ways for an HOA to bring a lawsuit on behalf of its members. So the court's decision was that the HOA lacked standing to a claim under the Right to Repair Act to sue for defects in the individual units, that the HOA has standing as to claims relating to defects in the common area, and that the HOA may have standing as to defects in the individual units if it can show that it meets the requirements of that section. So the next case is Fowler v. Golden Pacific Bancorp. This is a California Court of Appeals decision on an appeal for writ petition granted by the Superior Court of Sacramento County. The plaintiff, who was a director and the majority shareholder, petitioned for a writ of mandate against the corporation to enforce the statutory rights to inspect corporate books and records. The parties here are Rick Fowler, who was a director and the majority shareholder. He was also the COO of a law firm, KMTG, the defendant, Bancorp, Golden Pacific Bancorp, Incorporated Bancorp, is a bank holding company conducting business through its wholly owned subsidiary, Golden Pacific Bank. This bank has branches in Sacramento, Yuba City, and Live Oak, and it is now a subsidiary of SoFi. So for background, in July 2018, Bancorp filed a lawsuit against KMTG, Fowler, and an individual attorney at KMTG. The lawsuit arose out of KMTG's representation of Bancorp in a prior litigation against a company called BillFloat. The claims against KMTG and that attorney include breach of contract, breach of professional duties, professional negligence, and breach of fiduciary duties in connection with the prosecution of the eventual settlement of the BillFloat litigation. The complaint alleged that Fowler breached his fiduciary duties by persuading Bancorp to hire KMTG for the BillFloat litigation, despite knowing that KMTG was not competent to handle the litigation. It further alleged that Fowler used his position as a director to persuade Bancorp to settle the BillFloat litigation for a grossly inadequate amount because he knew that KMTG had failed to conduct sufficient discovery and that the investigation was insufficient to prepare the case for trial. So Fowler submitted an inspection demand. In September 2018, Fowler delivered to Bancorp a written demand to inspect and copy certain books and records. In his demand, he asserted that as a director, he has an absolute right to inspect records under Section 1602. And on this next slide, you'll see what 1602 provides. It says that every director shall have the absolute right at any reasonable time to inspect and copy all books, records, and documents of every kind, and to inspect the physical properties of the corporation. Next, Bancorp refused to permit inspection, citing conflicts of interest and concerns that Fowler was seeking records to undermine Bancorp's position in the malpractice lawsuit. Fowler then served Bancorp with a second request for production of documents, to which Bancorp refused to produce the requested documents. So Fowler filed a motion to compel, in which Fowler argued that the requested documents were relevant to Bancorp's claims and his defense in the malpractice lawsuit. Bancorp opposed the motion, saying, among other things, that most of the records being requested were irrelevant to that lawsuit and would only be of interest in his capacity as a disgruntled shareholder and director. The court agreed with Bancorp. It denied the motion to compel, concluding that the documents requested were overbroad, evaded third-party privacy rights, and it sought information that was not relevant. So in the trial court, Fowler filed an action to enforce the statutory right to inspect Bancorp's books and records. Bancorp opposed, and then the trial court granted the action. So next, Bancorp appealed, but while the appeal was pending, Bancorp was acquired by SoFi. And as part of the process, the board of directors were replaced, including Fowler. So next, the first issue for the Court of Appeal is whether or not this appeal is moot. Fowler is no longer a shareholder or a director. So the Court of Appeal say yes, that a director's right to inspect the corporate books and records ends upon his or her removal of office, but the scope of a director's inspection rights is one of public importance, which the court should decide even if it's technically moot. So next, the substantive issue. Did the trial court err in granting the petition to enforce Fowler's right to inspect corporate books and records under Section 1602? So under its plain terms, Section 1602 establishes a broad right of inspection, but it is subject to exceptions. So next, those exceptions are director's ballots, and that the court may place restrictions on access if the director intends to use those documents to commit a tort against the corporation. So the conclusion of this trial is that the court found that exception to the general rule favoring unfettered access should only be applied in extreme cases where enforcing the absolute right of the inspection would otherwise produce an absurd result. In its reasoning, California has adopted a strong public policy favoring a broad right of access to assist directors in performing their duties in an intelligent and fully informed manner. Second, by construing this exception broadly, it would risk allowing the exception to swallow the rule. And third, by applying the exception narrowly, it does not leave the corporation unprotected. The next case is Montes v. the YMCA of Glendale. This is another California Court of Appeals decision on an appeal from a judgment of the Superior Court of LA County. This is a premises liability question, looking into whether the apartment owner whether they had a duty to protect a resident. So the parties here are the plaintiffs. The plaintiffs are the parents of Abel Montes Jr., who was an apartment resident. The defendant is the YMCA of Glendale, which owned an apartment building that Mr. Montes Jr. resided in. For background, Mr. Montes, 23, was reportedly drinking and said that he was high after eating a brownie. And Mr. Montes went out for a night out, and when he came back to the building, the desk clerk in the building said that Mr. Montes was behaving erratically, rolling around against the floor and even falling onto the floor. But then Mr. Montes told the desk clerk that he was going back to his room. 2 hours later, the desk clerk looked outside and discovered Mr. Montes lying on the desk clerk's car, but alive. 1 hour later, Mr. Montes was pronounced dead. So next, the plaintiffs filed a wrongful death and survival action against the defendant. At the trial, the plaintiffs provided their evidence that the roof was in a dangerous condition and caused the decedent's fall in multiple ways, so they say. The evidence they provided was that there were no guardrails, walkways, or railing on the roof, and no physical barriers or warning sign to prevent residents from accessing the roof. There was a stairway to the 5th floor of the building, but there was nothing on the floor except a small doorway to the roof. There was no lock or other physical barrier on the ladder to the roof. The plaintiffs also presented evidence that the defendant knew residents went onto the roof. And it presented the fact that the desk clerk heard rumors that residents have been on the roof, not sure which one, since they have more than one roof on the building, but the desk clerk had heard rumors. And the plaintiff had an expert that went out onto the roof and said that he saw graffiti on the roof dated 2001, more than 10 years before Mr. Montes' death, and that the expert saw beer bottles and cigarette butts on the roof. So the trial court ruled in favor of the defendant. It found that the defendant did not owe Mr. Montes a duty to warn of or to remedy the open and obvious danger posed by the roof. The court observed that because there was no practical necessity for Mr. Montes or any individual to encounter the open and obvious danger, there was no harm there. So the plaintiffs appealed. So next, to prevail on the negligence theory, plaintiffs are required to show that the defendant owed Mr. Montes the legal duty of care with respect to the alleged dangerous condition that caused his injury. Here, that condition was the steep, sloping roof covered with brittle, broken, slippery, and unstable Spanish tiles. The existence of a duty is a question of law for the court. And whether a duty should be imposed on the defendant depends on various policy considerations. Prime among them is the foreseeability of harm to another. And the foreseeability of harm is typically absent when a dangerous condition is open and obvious. But generally, if a danger is so obvious that a person could reasonably be expected to see it, the condition itself serves as a warning, and the landowner is under no further duty to remedy or warn of the condition. And in that situation, the owners and the possessors of land are entitled to assume that others will perceive the condition and avoid that dangerous condition. So there's an exception to that, of course. There may be a duty when it is foreseeable that because of necessity or other circumstances, a person may choose to encounter the condition. So next, let's take a look at the application. This case turns on whether it was foreseeable that because of necessity or other circumstances, a person may choose to encounter the open and obvious condition. Here, there was no necessity or other circumstance that made it foreseeable that Mr. Montes would choose to encounter the dangerous roof. Mr. Montes was not required or even invited to expose himself to the risk associated with open and obvious danger. So the defendant owed no duty to do anything to protect Mr. Montes from his voluntary, unnecessary, and uninvited risk-taking. There was no practical necessity or other circumstance that might explain why it was reasonably foreseeable that Mr. Montes might choose to go on the obviously dangerous roof. So let's look at the implications for CIDs. Boards, property managers need to think about whether or not there are necessities or other circumstances that make it foreseeable that residents, guests, employees, or vendors might encounter a dangerous condition on the association-owned property. Next case, Hobbs v. City of Pacific Grove. This is a California Court of Appeal decision based on an appeal of the Monterey County Superior Court summary adjudication in favoring the city. Key question is, are short-term residence licenses constitutionally, are short-term rental licenses constitutionally protected properties? The parties here are two couples, William and Susan Hobbs and Donald and Irma Shirky. Each pair are owners of short-term rental licenses, and the defendant is the City of Pacific Grove. So as to background, in 2010, Pacific Grove had an ordinance that allowed for the transient use of residential property for income, subject to licensing, taxes, and other regulation. The licenses were issued upon application for a period of 1 year, subject to an earlier revocation for good cause. By January 2011, the city had licensed 85 active short-term rentals. In 2016, there's another ordinance. The city capped the overall number of short-term rental licenses citywide to 250 and further established a density cap at 15% per block. Next, in 2017, the city had another ordinance in which it reaffirmed that 250 licenses was in fact the maximum. It prohibited more than one license per parcel, and it required a 55-foot buffer zone of an exclusion between licensed properties, essentially so that when you couldn't have two short-term rentals right next to each other. There was also language that said that the city manager or his or her designee may delay or deny issuance of a STR license for any reason. It also had language that says no STR license shall be automatically renewed. And each applicant for a license was required to affirm this following language. I understand that this license expires on March 31st each year. Renewal of this license is not guaranteed, and the penalty for operation without a license is 100% forfeiture of the rents received. So in May 2018, another ordinance was passed. It selected certain licenses to sunset after a grace period following the scheduled expiration of the existing term. So the city conducted a random lottery, selecting 51 licenses to terminate on April 2019. Next, voters approved Measure M. Pacific Grove voters approved Measure M, by which the city would prohibit and phase out over an 18-month sunset period all existing short-term rentals in the residential districts except in the city's coastal zone as defined by the California Coastal Act. Measure M also provided that residents may allow short-term occupancy on their homes for home sharing, where the owner is on site during the stay, as well as house sitting, pet sitting, work trade, other similar arrangements which the voters deemed as compatible with the residential use. So let's take a look at the maps and show what the impact is. So Measure M had the effect of permanently prohibiting the Hobbs's short-term rental, which was in a residential district, and the Shirkey's property was in the coastal zone. It actually also had 2 licenses on site, one for the main portion of the family home and another for a separate guest quarters above the garage. The license for the Shirkey's main property was chosen for non-renewal in the lottery. So next, let's look at the trial court. The plaintiff sought declaratory and injunctive relief in December 2018, alleging that the city unconstitutionally deprived them of their right to allow guests to stay in their home. Count number 1 was that the city was required to obtain the California Coastal Commission's approval of the 2018 ordinance. And count number 2 was that 2018 ordinance violated the plaintiff's due process right by arbitrarily limiting the number of homes that can be offered as a short-term rentals and by subjecting them to random selection for non-renewal of the licensures. Also, they claim that Measure M violated Hobbs's right to due process by prohibiting all homes outside the coastal zone from being offered for short-term rentals. And the court determined that as to count 1, California Coastal Commission approval was in fact required. And on count 2, the court ordered dismissal of count 2 at the request of the plaintiffs after a number of the plaintiffs' motions were denied, so that the dismissal would be treated as appealable. So next, the threshold issues. Count 1 was determined to be moot. California Coastal Commission approved the city's local coastal program, including the subject ordinance. Count 2, the Hobbses lost standing by selling their home while this case was pending. And then the Shirkeys were determined to have lacked standing as to Measure M because their property was outside of the coastal zone and therefore not affected. So as a result, the court's review was limited to Shirkey's due process rights challenge to Ordinance 18-005. Next, plaintiffs contended that their economic interest in renting their vacation home exclusively for transient visitors was an entitlement subject to state or federal constitutional protection as a matter of law. We've got 2 sources of due process rights, the US Constitution and the California Constitution. Of course, in the US Constitution, it's the 4th Amendment, and case law goes to show that the requirements of procedural due process apply to state action infringing liberty and property interest. In order to have a property interest in a benefit, a person must have a legitimate claim of an entitlement to it. And these entitlements are created by state law. And in the California Constitution, it's found in Article 1, Section 7. Case law goes to show that a law regulating or limiting the use of real property for the public welfare does not violate substantive due process as long as it is reasonably related to the accomplishment of a legitimate government interest. An ordinance restrictive of property use will be upheld unless the due process attacked is able to show that the provisions are clearly arbitrary and unreasonable, having no substantial relation to public health, safety, morals, or general welfare. And a substantive due process violation requires some form of outrageous or egregious conduct constituting a true abuse of power. So next, the court found that there was no due process issues because there was no revocation of license during their term as to procedure, but that because the ordinance was rationally related to the city's goal of enhancing and maintaining its residential character, it was not so clearly arbitrary and unreasonable to find substantive due process. So keep in mind, if you are an owner in a separate interest in a HOA or other common interest development, remember that there are a layer of regulations that you have to comply with. In addition to your HOA's governing documents, of course, there are local laws, and state laws. And if you already rent out your unit on a short-term, intermediate length, or more typical term, you're likely already aware of this fact, that the number of regulations exist. But if you are considering renting out your units for investment or other purpose, just make sure to check the applicable regulations. Next, we have Arcadians for Environmental Preservation versus the City of Arcadia. This is a California Court of Appeals decision on an appeal from a judgment of the Superior Court of LA County. The parties are the Arcadians for Environmental Preservation, AEP. AEP is an organization led by the real party and interests next door neighbor, Julie Wu's next door neighbor. The defendant is the City of Arcadia, and Julie Wu is a real party in interest because she's not only a member in the Arcadia Highlands Homeowners Association, but she is a homeowner that wanted to carry out a project on her home, which was within the HOA. So let's look at the background. In June 2018, Wu submitted an application to her HOA for approval to expand the first story of her 1,960 square foot single family ranch style home and to add a second story. After holding several public hearings on the project, the HOA's Architectural Review Board denied approval for the project, citing the project's mass and height, as well as concerns over compatibility with the design of existing homes. Sounds familiar. In 2019, Wu submitted a second application to the ARB to address the concerns that the board had raised to her initial application. And as revised, Wu's project added 260 square feet to the first story and 1,140 square foot second story, as well as a covered porch and added to the existing rear porch. She changed the design to better fit with the design of the existing neighborhood. ARB denied the project as resubmitted. So April 13, 2020, Wu appealed the ARB's decision to the city's planning commission. Next, on May 26, 2020, the planning commission held a noticed hearing to address Wu's appeal and its staff recommendations. Community members spoke out in favor and against approval of the project, including the neighbor who founded AEP. He asserted that the design infringed on neighbors' privacy and explained that the occupants of Wu's property would have a direct view into neighboring homes. Following a hearing, the Planning Commission voted to adopt the staff's recommendation and conditionally approve the project, provided that Wu revise it to include 4 changes that the staff recommended. And the Planning Commission's ruling stated that the project was exempt from CEQA under Class 1 category exemption for addition to an existing facility. On August 4, 2020, the City Council considered the Planning Commission's approval, and it determined that the project was categorically exempt as a Class 1 under CEQA, and it upheld the Planning Commission's approval, subject to those conditions. Next, at trial court, following the City Council decision, the neighbor formed AEP, and then in September 2020, AEP petitioned the Superior Court. The Superior Court denied the petition in February 2022, so AEP appealed the Superior Court's judgment. So next, let's talk a little bit about CEQA. CEQA is a CEQA review is undertaken by a lead agency, which is defined as the public agency that has the principal responsibility for carrying out or approving a project which may have significant effect on the government. First, the agency determines whether the proposed activity is subject to CEQA at all. So in practice, this means that this requires the agency to determine whether the proposed activity constitutes a project at all, as defined under the CEQA guideline. If not, the lead agency may proceed without further regard to CEQA. Second, assuming the activity is a project, the agency must decide whether the activity qualifies for a statutory exemption or if it's one of the 33 categorical exemptions in CEQA's implementing guidelines. If the lead agency determines that the proposed activity is a project subject to CEQA and not categorically exempt to CEQA's requirements, CEQA requires that the agency undertake an initial study to determine whether the project may have significant effect on the environment. If the initial study finds no substantial evidence that the project may have significant environmental impact, the lead agency must prepare a NEGDEC, a negative declaration, and the environmental review ends there. If the initial study finds potentially significant environmental effects, but one, those effects can be fully mitigated by changes in the projects, and two, the project applicant agrees to incorporate those changes, then the agency must prepare a mitigated negative declaration, and then this too ends CEQA review. However, if the initial study finds substantial evidence that the project may have significant environmental impact and a mitigated NEGDEC is inappropriate, the lead agency must prepare and certify an environmental impact report, EIR, before approving or proceeding with the project. Next, the court looked into whether or not exhaustion of the remedies was performed. Exhaustion of administrative remedies is a judicial prerequisite to maintaining an action alleging the lead agency's non-compliance with CEQA. And a challenge to an agency's findings that the project is categorically exempt to CEQA under the CEQA guidelines is subject to the exhaustion requirement. The purpose of this doctrine is to afford the public agency the opportunity to hear and respond to articulated factual issues and legal theories before its actions are subject to judicial review. To achieve this purpose, the exact issue must be presented to the agency. So, notably, bland and general references to environmental matters or isolated and unelaborated comments do not satisfy the exhaustion requirement. It's not enough to just generally object to the project or the project's approval. The petitioner bears the burden of demonstrating the issues raised in the petition that they were in fact presented at the administrative level. So next, the appeals court. The decision was that AEP did not satisfy the exhaustion requirement. AEP alleged that the city erred in concluding that the project fell within the class 1 categorical exemption, but according to AEP, he said that it fell outside of the scope of this class 1 exemption, but no member of AEP objected on this ground at the administrative proceeding. Any project that comes within class 1 categorical exemption has been inherently determined by the Secretary of National Resources Agency not to have significant environmental impacts. So in order to preserve their challenge, the neighbor or any AEP member would have had to at least articulate why the application of that exemption might be incorrect. None of the general statements came close to apprising the city of the neighbor's contention that it fell outside of this exemption. So let's look at the implications. Project opponents must exhaust administrative remedies. It's not enough to just generally state opposition and broad environmental impacts when making a claim under CEQA. And those are the cases I wanted to cover with you today. Dave?
All right. Thank you so much, Louis. We appreciate it very much. This Q&A session is going to be sponsored by the Farmers Insurance Agency, the Kevin Boland Insurance Agency. So thank you so much, Kevin, for doing that. we'll take a few questions here and then we're ready to go. Let's take a look at our Q&A box. And if you have a question, again, let me respond. And we don't have very many questions today. If you could put your questions in the Q&A box and then use the upvote feature, that will help us quite a bit. And we'll get to the number 7 upvotes is for owner to owner problems or neighbor to neighbor problems, I would say as well, where an owner files a claim of discrimination based on race. Does an insurance cover this issue? Can you get in coverage for that?
I think it depends on how the claim is made and against whom. I've seen carriers provide coverage, or at least indicate that there was some defense, and provide panel counsel to investigate or to actually defend against this. So obviously it depends, and take a look at your insurance policy, but it may cover this issue.
Okay, and make sure you talk to your qualified HOA insurance agent. They should have the answer.
Exactly, and I would also add that boards, if they do get an inkling of a potential claim based on race discrimination, that they, like other things, need to investigate it, determine whether or not there's any merit to the claim, or see if it needs to be escalated.
Okay, and Clifford asks a good question. I think it's this has come up with me as well. Are public censures by the board subject to defamation lawsuits? And if so, is malice, willful, reckless disregard for truth required to establish the claim?
It would seem so. So defamation would be completely separate. Defamation lawsuit would be different from the First Amendment retaliatory claim here. Of course, you have to look into the intent if you're going to have a defamation lawsuit, and look at whether or not the claim has any truth, and that veracity is going to be explored in the lawsuit.
Mm-hmm. That makes sense. Okay, Anonymous asks, too confusing to relate the examples to HOA. How about specific examples of actual HOA lawsuits? Do we have any specific lawsuits like that?
I'm sorry. A few of these involved HOAs, and others involved particular elements of the law that affect the directors, or affect different aspects that relate to HOA. So, I mean, certainly the Riverside case involved the HOA as a party, and there was an HOA involved in the Arcadia case, but as the board knows, and as legal counsel knows, not all cases are solely going to be based on the Davis-Sterling Act.
Okay, and so let's take a look at some of these other ones, and please give me an example of CODs. Okay, your pre-meeting bullet points: construction defect claims, HOA association standing to bring defects and claims on common areas, and may have standing for individual residential units. Does the 10-year statute of limitations definitely negate said standing, despite the serious possible life-threatening defects not being discovered until 10 years since the original construction, allegedly negligent in nature? I think it's a CD question, right?
It depends on, but that 10-year statute of repose tends to be a pretty hard one. I guess it depends on the particular element that the defect arose in, and if it was in fact discovered until much later. I think it really depends on the facts on the particular portions of the common area that's affected. But certainly there's the Right to Repair Act, as well as the Davis-Sterling Act, that sets forth the pre-litigation process that the HOA or any owner can start to proceed towards to try to address those defects.
Okay, appreciate that. Okay, and then Angelica Resendez asks, do you have the section number in the slide entitled Riverside at Washington Square, HOAV, the Yolo County?
What section number in the slide? Yeah. So there were 3 sections involved. Let me pull out that. Oh, from Connor, actually wrote it. Civil Code section 5980, Civil Code section 945, and the third is Code of Civil Procedure section 382.
Okay. Got those. Were you complain against the HOA mismanaging? I don't understand that question, so I'm going to move on. Should the board directors be given a key to the roof to inspect it when there is a water leak?
Should they be given a key to inspector when there's a water leak? Certainly, the inspectors have a duty to investigate items that affect the association or the building. And if this is not being done by a property manager, then yeah, the board should be investigating the water leak.
Sure, yeah, makes sense. Okay, can you discuss the duty? What duty does the board have to owners if one of the board members harasses the owners? The problem is that that other board members are afraid of the offending board member in fear of retaliatory discrimination suit. So this leaves other residents at risk of continued harassment. This was an issue of our former board had for years ago, was a duty to protect here. And especially since it was a sitting board member.
Sure. So the board has a duty to investigate. And depending on the basis for the discrimination, the board may have an obligation to do what it can to stop the discrimination, just to stop the harassment from happening currently, and take steps in the future to do so. So I guess it depends on whether or not a complaint was made to the board, and if it was, then the board has an obligation to investigate, to determine whether there's any truth to it, and to take steps to try to prevent it from happening.
So there's a question in the chat that Connor said I missed, is please give some examples of CID areas of risk for foreseeable dangers. Like tree falling, would that be one?
Risk of foreseeable dangers. Well, if there are any elements in the common area that are there, so the case law involved. Well, I mean, this particular case involved a roof. So if, for example, there was a roof deck that they knew that everyone went out onto, but then there was elements of that roof deck that led to an open and obvious danger that was adjacent to it, but that was not protected against, then that would be one example. One example that I can think of from practice is that this firm actually represents a few high rises in San Francisco, and those high rises have satellites or have elements of the roof that need to be repaired. And that one particular building I have in mind has different systems that are on the roof to ensure that vendors are able to clip in and ensure that they won't fall off the roof. So even if that danger doesn't necessarily involve the residents going onto a roof or a common area. If it's foreseeable that a vendor might have to go up there, then that might be an instance where the association, the board, or the property manager has to think about what steps it's taking to prevent those foreseeable dangers.
Okay, so some of these questions are less related to the cases, but more related to just how you work with your attorney and what the responsibilities are. So we do have an Ask the Attorney meeting coming up very soon, and those are better handled in those meetings. And here's one of them. I'll give it to you now. How do you deal with an attorney that is working in favor of the HOA, but not in favor of the community in general? I presume this is the HOA board's attorney, and so the point is that he's hired by the board, correct?
Well, the HOA's counsel is hired by the association, and the board of directors is presumed to be acting in the best interests of the community. But it sounds like this attendee is saying that it seems like the board might not be acting in favor of the community at large. But in general, that attorney has as a client or contact as the client would be the board of directors.
Mm-hmm. That's right. And okay, and here's an anonymous attorney. In California, the quarantine mandate has lifted and the board continues only to use Zoom. This leaves out many that do not have computers, smartphones, know-how, how to join. They don't have the know-how to join meetings. Further, it creates a them versus us attitude, as owners are not being able to ask their questions. Owners feel left out. So how do you deal with because now we're seeing a lot of issues where people were used to the remote, it got great reviews, lots of participation,
Right.
But now they're supposed to have a location. So
right, it goes back to having that requirement to have a physical location. Some members may still dial in or use Zoom, but there should be a common room or some other physical location that others who want to attend in person should be able to attend. So this might be an instance of raising the issue to the association's council if it has it, or to the property manager, or even to the president to say, look, this is not in compliance with the requirements when it comes to holding a meeting.
okay, and so we're getting into many more of these that are more about the relationships and management and what have you, and less about case law. We have a little time here. We have a few
Sure.
minutes, so we can take a couple of these, but really they should be they should be asked at a different venue. Why can't we sue the management company for their failures or misconduct?
I guess it would depend on who is we. So the board of directors has the power to hire and fire the management company. So if the members have a problem with the way that the management or that the company is managing the association, then they should bring that up with the board and see if it makes sense that the board want to take a look at the relationship that they're having with the management company. But if the question is suing the management company, assuming that the board of directors had already found that there are failures or that there are misconduct, then the association should really look at the agreement that it has with the management company, because it might say whether or not there are any protections that are baked into the management agreement.
Okay.
Again, raise it to the board should bring it up with council.
Right, and then and I think the short answer is that you can sue just about anybody, right? So that's the bottom line. Where to complain against HOA board members if you feel they're mismanaging the HOA? So how do you, if you're a homeowner, how do you reach out to the and try to make change?
How do you reach out to the against the board members who are mismanaging the HOA?
Yeah, what she's saying, she wants to make a complaint against the board, but who do they talk to for mismanaging the HOA?
You've got to bring that up with your fellow members. If you think that there's enough of a groundswell of other members who feel like the board or a particular director is not acting in the best interest of the association, then you've got to make that public. If there's enough of desire to get rid of that director, then members might want to look at the recall process. But it's all about bringing it up to the members and seeing if there is the appetite to try to get that director out of their seat.
Yep.
And I also add that in open meetings, or sorry, in meetings of the board or of the membership, there should be an open forum process or a portion of it in which members should be able to speak freely about items that are on the agenda or not on the agenda. And then if not, there's always old-fashioned way with snail mail or email and try to get in contact with the other members to figure out how they are also feeling about this director.
Mhm. Okay, so just a couple more questions here. Must an HOA fence off a natural bluff at the edge of the property?
I guess it depends on whether or not there's any foreseeability of anyone having to go over the bluff. But if it's anything like this coastline, I can't obviously tell you exactly if you do fence it off or not, but it does seem to be open and dangerous. It's something that the association should take into consideration if there's a trail nearby, or what the likelihood of people being near the edge of the bluff.
Got it. If homeowners are forced to hire an outside counsel because board and management attorneys aren't listening to the homeowners, are we entitled to be reimbursed for money spent?
No, not unless the governing documents state otherwise. The association has its own counsel, and they're going to rely on that counsel. And basically, that special counsel is being hired by the homeowners in order to advise those homeowners of their rights in the association. So unfortunately not. If it gets to the point where there's a lawsuit raised or arbitration or mediation involved to enforce those members' rights, then perhaps as part of the process and as a prevailing party, they can seek attorney's fees in order to enforce the members' rights. But as the question's presented now, the homeowners are not entitled to reimbursement for the attorney advising those members as to their rights and obligations.
Gotcha. And so I think what we're going to do now is just wrap it up, and appreciate everybody coming today and being part of this. Thank you, Louis, for your words and putting the time and effort into a great presentation. I know we'll have these sent out very shortly, so thank you so much for doing that.
Thanks, Sam. Got it.
And so thank you all to all our members that participated today and for supporting our ongoing ECHO webinars. For those of you joining us today who are not members, you are invited to become members. You or your community can join by just simply going to www.echo-ca.org and clicking on our membership tab. For our members, please invite your friends, boards, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes. This year, ECHO has been celebrating or has plans to celebrate its 50th anniversary, and we will have special activities planned throughout the year, including a grand 50th anniversary celebration scheduled for Friday, May 5th, Cinco de Mayo. So we hope to see you there. You'll see registration information out very soon. I think tomorrow we're planning to send it out, or Saturday. We hope to see all of you ECHO members at this amazing milestone event. If you have some time and would like to become involved with ECHO, please, we have a few opportunities for you. Please refer to the slide. If you see anything that looks interesting, please send me an email at dzappone@echo-ca. Currently, ECHO is looking for and event coordinator and administrative support. This is a perfect opportunity for a highly organized self-starter who is interested in learning event planning. The position is part-time and work at home. Now, for some other announcements. The San Diego Resource Panel, its first meeting, is going to be next week, March 30th from 11:30 to 1 p.m. at the Mission Hills Hillcrest Library. There is free parking below the library, and for homeowners, there is no cost to attend. We will be discussing insurance matters, including the availability of insurance, denials, and managing risk. With this stormy weather we've been having down here, it's going to be quite a vibrant and interesting conversation, I'm sure. Also, we invite any HOA board members or former board members to join the ECHO Board Members Club. The club meets via Zoom every second Tuesday of the month from 5:30 to 7 p.m. I see Miguel Sanchez is on this call today, or webinar today, as well as Carolyn Fergoda. Both of them are part of the Board Members Club. We hope to see you there. It's a great opportunity to talk and meet your and connect with your HOA board members. The next meeting, the meeting next week will be a highly interactive discussion on insurance, no less, the topic of the day. I expect this hot topic to generate some lively conversation in our small breakout rooms. We hope to see you there. The Board Members Club is open only to members of ECHO and those who serve or have served on an HOA board. It is an hour and a half long from 5:30 to 7 and conducted online. Please contact Connor for more information. Once again, thank you to our sponsors for making this workshop possible. Thank you to our faculty for Lewis, thank you, for designing and presenting the program. And of course, all of you for attending today and making this event a success. ECHO appreciates your investment in education to foster a better quality of life in HOAs.